Good afternoon, everyone. Good afternoon. You're all very welcome to another Human Rights Centre seminar today. My name is Colin Harvey. I'm from the School of Law Director of the Human Rights Centre. For the seminar this afternoon, we have an online audience. Hello, online audience, and we have an in-person audience as well. What I'm going to ask of the online audience, if you would like to ask a question, we're going to do that through the chat function. So drop any questions into the chat function there, and online in-person audience can raise your hands and we'll have a discussion. In terms of our speaker today, Professor Brice Dickson, Emeritus Professor, but we'll call him Professor Brice Dickson. Before I say something about Brice, just want to say something about the Human Rights Centre at Queen's, looking around the room, who's online as well, that there's quite a lot of reflection this year on Northern Ireland, this place, and the Belfast Good Friday Agreement, and 25 years and all of that. But one thing I do want to note as Director of the Human Rights Centre, I'm only the latest, although I've done it before, you always do jobs here more than once, of someone who's directed this Human Rights Centre. The Human Rights Centre Queen's been around since 1990. I've worked in many, many places. Not that many, actually. I've worked in a few places. I've never worked somewhere with people, an institution, law school, Human Rights Centre, who are so personally committed to making a difference, not just in the classroom, although monumental efforts in relation to that and in research, but just in wider society here. And many of us have really been around for a very, very long time. And I've never met a group of people who care more about this place. And the Human Rights Centre and its work, and the human rights work that goes on here is evidence of that. So what I'm trying to say in a very long-winded way, and thinking about Brice, who's recently retired, but Brice never retires, as you know. His latest opus there is it been an absolute privilege over many, many years to work with absolutely legendary and outstanding colleagues like Brice, and to continue to do so. People who care so passionately about human rights here, there, and everywhere. Brice doesn't need an introduction, right? But you know what I'm going to say next. I'm going to do one anyway. It wouldn't be fair not to. But his long-standing colleague at Queen's, who is, I'm going to say, scarily widely published, prolific, whatever way you want to say it. And I could spend the rest of Friday afternoon outlining his many, many contributions to human rights. So starting from a working way, but I'm not going to do that. His latest book is on the table and is here. And in a moment, I'm going to pass it round, but you're not allowed to take it. Right? You have to give it back. Put it table offers to give you a sense of the contributions that this man has made really to human rights in this society and beyond. His textbook, Law in Northern Ireland, which is in the what edition, right?
Depends how you're counting. The fourth
edition of Law in Northern Ireland is the text on law here that everybody uses. And worth noting as well, it's done a great service because looking around the room, and many people will know, collating, bringing the law of Northern Ireland to a wider world is no mean feat when you're trying to persuade publishers to take that step. And the people who do that work are really undertaking a really important task. And Brice is commended for doing that. Not only content with making an outstanding contribution to university life, Brice has also been widely involved in public life in Northern Ireland and beyond. And just to mention his roles as Chief Commissioner of the Northern Ireland Human Rights Commission, the first Chief Commissioner of the Northern Human Rights Commission. We're thinking about the agreement this year. And also his role as a member of the policing board as well, and other roles too. So as I say, I could go on and on and on and on and on, but I won't. You don't want to hear from me. So without further ado, I'm going to introduce you to Professor Brice Dickson, who's talking about the UK's engagement with international human rights monitoring mechanisms. Thank you all very much for attending, both online and in person. I'm going to hand you over to Professor Brice Dickson. Thank you all very much.
Thanks, Colin, for embarrassing me again. This was meant to be my COVID, well, it was meant to be a project starting in 2019, but it turned out to be my COVID project. I'd got a small amount of money from the Leave of Hume Emeritus Fund to undertake it and to travel to Geneva and Strasbourg and participate, insofar as one can, at committee meetings there to do with human rights issues and interview people in person all around the place. That didn't happen, of course, because of the lockdown measures in 2020. But I was still able to do a number of the interviews online or by telephone, and a lot of documentary work. So the talk and the book on which it's based is looking at a very particular kind of enforcement mechanism for human rights. Not sure why that's not flicking on there. Yeah, thanks. Yeah. This doesn't appear to work. Pardon? Okay. Okay, thanks. So I'm not looking, sorry, it's the previous slide, yeah. I'm not looking at the adjudicative mechanisms, the courts and the committees that deal with complaints on human rights. I'm not looking at the investigative mechanisms, that is the inquiry powers that various treaty bodies have, or the special procedures that are set up by the UN and the Council of Europe. So special rapporteurs, for example, not looking at them. And I'm not looking at the NGO monitoring that goes on a global basis, sometimes by groups like Amnesty International and Human Rights Watch. What I'm looking at are the evaluative monitoring mechanisms set up on a periodic basis, to operate on a periodic basis by intergovernmental organizations, principally the UN, the Council of Europe, and to a small extent, the European Union. So when you I'm sorry, this is still not working for me here. Sorry, Colin, you're going to have to do this for me. These are the bodies I was looking at. There are 10 UN bodies. So the Human Rights Council, which conducts its universal periodic reviews. There's the 7 treaty bodies: racial discrimination, the Human Rights Committee, which deals with civil and political rights, CESCR, which deals with economic, social and cultural rights, CEDAW, women's rights, CAT, torture, CRC, children, and CRPD, the Disability Committee. Those 7 treaty bodies, together with a protocol body, that's the OPCAT protocol, which is a subcommittee on prevention of torture, which isn't really a monitoring body in the treaty body sense, because it inspects rather than monitors, but I've included it because I think it complements the CAT stuff quite well. And then I've looked also at the International Labour Organization's monitoring mechanisms. They have a committee called the Committee of Experts on the Application of Conventions and Recommendations, been going since 1926. So it's by far the oldest of all these treaty bodies, and in many ways one of the most effective. Then I'm looking at the Council of Europe bodies, so the Commissioner for Human Rights, who again doesn't operate quite as systematically as treaty bodies would, but who says a lot about individual countries on an ad hoc basis and has said some things about the UK. Then the 6 treaty bodies from the Council of Europe, so the Committee for the Prevention of Torture, the European Committee of Social Rights, COMEX, which is the Committee of Experts for the Charter of Languages, the Advisory Committee for the Framework Convention on National Minorities, GRECO, which deals with corruption issues, GRETA, which deals with human trafficking. Not GREVIO, which I'm sure you all know is the body that looks at the Istanbul Convention on Domestic Violence and Violence Against Women. The UK only ratified the Istanbul Treaty in July of last year, so there is no monitoring yet to assess. And then the European Commission on Racism and Intolerance is, if you like, the Council of Europe equivalent to CERD for the UN. And then there's the Fundamental Rights Agency for the European Union, which, alas, will not be continuing its monitoring of the UK as the UK has left the European Union. So those were the bodies concerned. Now, the methods that I was using in doing the work was obviously to look at the existing academic literature. There's not a great deal, amazingly, comparing and contrasting the UN bodies with the Council of Europe bodies. There's no single book that does that. There are separate books on the UN bodies and the Council of Europe bodies, but in fact, only one on the Council of Europe bodies, and that's already over a decade old. And even when you look at those books, they don't cover the full range of treaty monitoring bodies that exist either in the UN or the Council of Europe. So the UN books don't look at the International Labour Organization, for example. I then was focusing on the impact of all these monitoring bodies on human rights protection in the UK. This is basically an impact study. The aim was to go through all the reports submitted by the UK to these bodies over the years and all the reports sent to the UK by the monitoring bodies over the year to get a feel for what difference these bodies were making on the ground to the protection of human rights. To do that, I conducted several interviews with various experts who were either members of treaty bodies or officials working for treaty bodies, as well as some academic experts in the field. And I watched some video recordings of the UN interactive dialogues. As you probably know, since 2016, there's a UN TV service on which you can see a lot of these meetings happening in person. There's not, unfortunately, any dealing with the UK, I think possibly except for the Disability Convention. There's very little video footage of UK meetings, but even looking at other countries' meetings gives you a feel for how they operate and whether they're really getting at the bottom of what the monitoring bodies need to know in order to make a proper assessment of the country in question. The focus in the book and today is on the reports dating from the year 2000. And that actually includes 6 of the bodies that only started from 2000. A number of these are quite recent bodies, including, for example, the Disability Committee's work and several of the Council of Europe bodies. So this is not there's not a great history to this kind of monitoring work, and it's still being added to, as I mentioned, through the GREVIO committee. The way I grouped the mechanisms when doing the work and writing the book was as seen on the slide there. So I looked at general monitoring, first of all. That's the universal periodic reviews carried out by the Human Rights Council, the work done by the European Commissioner for Human Rights, the work done by the Fundamental Rights Agency. And there's a little bit in the book, excuse me, on the work done by the Parliamentary Assembly for the Council of Europe, which has various committees monitoring human rights in the various countries of the Council of Europe. But they tend to be the more problematic countries. And although we might think that the UK is problematic in all sorts of ways, it's not as problematic as many of the European countries. So it hasn't really come under the scrutiny of the Parliamentary Assembly to any great extent. Having said that, the Parliamentary Assembly was to the fore in highlighting the issue of extraordinary rendition during the Iraq and Afghani wars. Then I moved on to look at civil and political rights. So that embraces the Human Rights Committee, which of course monitors the ICCPR, the Torture Committee, the UN and European Prevention of Torture Committees, which, as I said earlier, inspect police stations, detention centres and the like in the UK, and then Greta, which deals with human trafficking. Those are the main civil and political rights monitoring bodies. Then I grouped the economic, social and cultural rights bodies, the UN CESCR, the European Committee of Social Rights, and the ILO work, together with Greco, the corruption body. Again, that's not a body which we in the human rights field tend to pay much attention to, but the Greco committee is right, I think, in saying that the criminal and civil law corruption conventions, which the Council of Europe has issued and which are ratified by many, indeed most European countries, are fundamental to the preservation of democracy and the protection of human rights throughout the continent of Europe. So it is an important committee and it does good work. Then I moved on to racial and minority discrimination. So third, ECRI, the Advisory Committee of the Framework Convention, and the Committee of Experts on Languages. And then finally at gender, age and disability discrimination, women's rights, children's rights and disability rights. Now, I wanted most of this talk to be devoted to the findings that I came to. I should begin by saying that a huge amount of fantastic work is done by these monitoring bodies. I'm not denying that. They have the effect of keeping the focus on the protection of human rights on an ongoing basis. So officials at all sorts of level within the UK and government ministers, etc., have to keep a constant eye on their obligations under the human rights treaties, because they know that imminently they're going to have to answer for their work on those human rights standards to the various committees which are monitoring them. And that does focus the mind. And it also helps, of course, to spread the word about human rights obligations, because lots of civil society organizations, lawyers of various descriptions, other NGOs engage with these treaty bodies as well. And all of that work keeps human rights central to the governance of the country to a very large extent. However, it is very difficult, and I would say, having done all this work, virtually impossible to say that any change to the protection of human rights, whether in law or in policy in the UK, has resulted from the monitoring systems. That sounds like a negative, but what I'm really saying is it's impossible to prove or demonstrate that change resulted from the treaty monitoring body's work. When a policy or a law is changed by the government or parliament, we never are told that it's done because a certain treaty body requested it. And that's often because, excuse me, in fact, not often, I would say always, it's because the treaty body's recommendations for improving the protection of human rights come on the back of work that has already been done by NGOs and other pressure groups within the countries themselves. So nothing which any of these treaty bodies has said about the UK has not already been said by some pressure group pressing for reform. And therefore, when the reform happens eventually, it's impossible to say that was because of the initial pressure by the pressure groups or by the additional pressure added by the treaty bodies. Proving cause and effect, in other words, direct impact is almost impossible. On top of all that, an overall message from this work is that the treaty bodies, whether they are UN bodies or Council of Europe bodies, are actually, and it's a bit heretical to say this, especially in this company, is a bit chaotic, unsystematic, and inefficient. It's the best we have, but it could, I think, be a lot better. So the first negative critical remark I make then here is that these bodies operate very slowly, especially at the UN level, which means that by the time their conclusions are issued, they're often out of date. They often refer, excuse me, to a situation that was existing on the ground up to 10 years earlier. That's as far back as the UN ones go. Sometimes the Council of Europe ones go back maybe 6, 7, or sometimes 8 years. So the picture has already moved on by the time these treaty bodies have issued their concluding observations. Secondly, there is significant overlap between the mechanisms, both within the UN itself and between the UN and the Council of Europe. So if we take the issue of racism, for example, there are no fewer than 5 UN bodies that look at racism in the UK. You've got the Universal Periodic Review, you've got the Human Rights Committee, you've got the CERD, you've got CESCR on economic, social, and cultural rights, because it too looks at how different racial groups are adversely affected when it comes to the protection of economic, social, and cultural rights. And the CRC and CAT also take account of racism when issuing their conclusions. And at the Council of Europe level, you've got the Economic Committee of Social Rights, you've got COMEX, and you've got Greta on the human trafficking issues, which also frequently refer to racism and intolerance issues. And if we take violence against women and girls, that's another issue which is looked at by multiple bodies. So at the UN level, again, we have the UPR and the HRC, we have CEDAW, we have the CRC, and we have CAT. And at the European level, the Council of Europe level, we have Greta and now the Gravio Commission as well. And the overlap wouldn't really matter that much if there were good coordination between the overlapping committees, but there isn't. They tend to repeat what other committees have already said. They ask the same questions of the state representatives that have been asked at previous interactive dialogues. They even repeat the same conclusions as other committees have come up with. The only real examples of cooperation between the UN bodies and the Council of Europe bodies are at the level of, first of all, economic and social rights. So the International Labour Organization sends a representative to meetings of the European Committee of Social Rights. I'm not sure that that representative always attends or contributes much to the discussion, but they're there, and I imagine that away from the formal meetings, there's quite a bit of interaction there to ensure, amongst other things, that the Economic Committee of Social Rights is singing from the same hymn sheet as the ILO is, as regards trade union rights and employment rights more generally. And at the prevention of torture level, the European Committee for the Prevention of Torture liaises quite closely with the subcommittee on the prevention of torture at the UN level to ensure that it's not duplicating what the SPT has done. It's common now for concluding observations of the ECSR or the CPT to refer to conclusions that have already been reached by the ILO or by the SPT. But a lot more interconnectivity could be put in place between the various bodies. Then to be very pragmatic for a moment, the fact that the UN imposes quite strict word limits on the documents it handles is very restrictive when it comes to the human rights monitoring systems. So if a state is submitting a report, it can't write more than 21,200 words. When the committee body is sending a report back to the state, it can't write more than 10,700 words. Now, I know if you're writing a master's dissertation or something, 10,000 words is a lot. But when you're reporting on the human rights situation concerning a multiplicity of human rights in a whole country, 10,000 or 20,000 words is not a lot. And the UN works to two crucial principles: the principle of universality, so every country in the world has to subject itself to these systems, and equality, which means that every country has to be dealt with in the same way by all of these systems. So whether you're Vanuatu or China, your report to these bodies, to the am I not on? Okay. Conor McCormick, who's in the audience here, and Jane Rooney from Durham are editing a special issue of the Northern Ireland Legal Quarterly on devolution and international law. And I've done a chapter for that, which tries to pick out from the treaty body work all that's being said by the state, the UK government, and by the treaty bodies themselves about the three different devolved regions of the UK. And my conclusion out of all of that is that in the last few years, there's been a great improvement, A, in the way that the UK reports on the devolved regions, and B, on the way the treaty bodies react to those reports and make recommendations, sometimes directly to the government of the devolved region, rather than to the national government. While, of course, they always say, quite rightly, that the ultimate responsibility for adhering to the treaty obligations rests with the national government and not with the regional government. But these word limits do make a difference to the effectiveness of the UN system. The word limits don't exist at the Council of Europe level, which in general, I think, operates much, much more effectively than the UN bodies in this context. The UN could virtually double its productivity in its work on monitoring if it were to divide its committees into chambers, just two chambers, which would sit separately and monitor countries in parallel. That has been done to some extent within the Council of Europe, although even there it's not generic. It's been done at the UN level by the CRC and by CEDAW with the special permission of the UN General Assembly, but it's very much frowned upon. It was allowed in those two cases because the backlog of reports before those two committees was getting insurmountable. But it's generally frowned upon because it theoretically breaches the principle of equality. You might end up with one chamber coming to different conclusions about country X, than another chamber would come to on the same issues vis-a-vis country Y. And for some unknown reason, the UN bodies can't get their act together to be more efficient and maybe having an overarching a system whereby the chambers report to the committee as a whole, which then formally endorses each of the chambers' reports. That doesn't happen, but it should, in my view. And the UN system also relies a great deal on face-to-face dialogue with state representatives, which means, of course, state representatives going to Geneva, all the cost that's involved in that, the environmental damage that costs. And you might think, well, at the end of the day, they end up spending at least 3 hours, sometimes 6 hours, having a head-to-head with members of the committee. And that's true, and a degree of trust and understanding can be built up. But if you watch some of the videos that I referred to earlier, you come away with a feeling that everything is quite formal. Some of the speeches are quite long. Some of the questions are quite long. A lot of the answers to questions are quite evasive. And it's very rare for the committee, in my view, to, not that they come to a conclusion there and then for the benefit of the audience, but in my view, it would be quite difficult for the treaty body committee members at that stage to come to a definitive view on whether the UK or whatever country it is complying properly with the standard human rights, the human rights standard in question. It might seem paradoxical, but I think it's easier to do that through documentation and an exchange of correspondence, which is really what the Council of Europe does, than it is through the face-to-face dialogues. I attended a couple of online conferences to do with this kind of work during the COVID period, and I had the temerity to suggest that the interactive dialogues weren't so vital to the process. And of course, they weren't happening to the same extent during that period because of COVID. But I was shot down by virtually everybody on the call because that was deemed to be going back to the old days when state representatives didn't come in person and have to account for themselves in person. And try as I could to sort of get to the efficiency of it all and the effectiveness of it all, I couldn't persuade them that the dialogues were, in most cases, in my view, superfluous. Next slide, please, Colin. Thank you. I also have the temerity to suggest that sometimes the UN bodies are too easily influenced by NGOs. Now, this is partly because they are fed a lot of information by NGOs. They don't have time to interrogate the information, to validate the information. They are the subject of lobbying by NGOs. And I have seen occasions when recommendations are made by these treaty bodies that quite obviously come from NGOs, but for which I don't think there is sufficient evidence to justify the conclusion coming from the treaty body. And I'm going to stick my neck out even further on this and give the Bill of Rights in Northern Ireland as an example of that kind of activity. Time and time again, we see these committees calling for a Bill of Rights for Northern Ireland, and that's fine and dandy, and I support that in principle. But there's never any kind of acknowledgement about the work that's already been put into that, achieving that, and B, the political realities facing the people who are trying to achieve that. There's a kind of disconnect between the politics and the legalities sometimes, a kind of unreality on the part of some of the committees. And it's undeniable, I think, that the treaty bodies engage in mission creep. If you look at the general comments that are issued, the general recommendations that are issued, they go way beyond what the treaties themselves say. For example, none of the human rights treaties require countries to incorporate the treaty into their domestic law. But time and time again, the treaty bodies say to states, you must incorporate the treaty into your domestic law. They say as well, you must have a national strategy for how you're going to protect children's rights, women's rights, whatever it might be, ignoring the fact that there are all sorts of ways of protecting rights other than through national strategies. The fact that a treaty hasn't been incorporated doesn't necessarily mean that its standards are not being upheld in that country. The treaty bodies often are pusillanimous in what they say about states. They pull their punches. They apply diplomatic language when actually they should be quite blunt and rude in many cases, as the Council of Europe is in a different way, as I'll come to. And they're not great at following up the recommendations that they have made and whether they've been properly implemented. The different UN treaty bodies differ between themselves in how they go about that. And at the end of the day, they sign off on implementation in a way which, in my view, is very lax. They rarely get to the bottom. They rarely are able to say that they're completely convinced that the human rights situation on the particular point in question has been changed in the way that they wanted it to be changed in a particular country, excuse me. And of course, geopolitics comes into all of this as well, especially at the UPR level. The UK's fourth UPR happened in November of last year after I'd finished this book, so I couldn't take it into account. If you've looked at the working group's report, it has 302 recommendations made by over 100 countries. These recommendations are 2 lines often. They're at a very general level. Countries like China, Russia, Iran, Syria make multiple recommendations as to how human rights in the UK could be improved. China, for example, is calling for better treatment of Islamic minority groups in the UK. China is calling for better protection of Muslim minorities. Lesotho, which has a pretty bad record in delivering reports to the UN treaty bodies, is calling for greater punctuality by the UK in the delivery of its reports to the UN bodies. There's a lot of politics, to the extent I think I have to say that the UPRs are, and Catherine McNeely, I'm not sure if she's online, but she's looked closely at UPRs. I would suggest the UPRs are pretty useless when it comes certainly to the UK's monitoring, the involvement of the UK in monitoring. It doesn't help at all, but the principle of universality requires every country, of course, to go through the process. It may be ironic, but the only example I was able to find in all of my work on this of there being a direct impact on the protection of human rights in the UK was not through the monitoring system itself, but through the inquiry system which CEDAW has at its disposal. There are 6 UN treaty bodies that can conduct inquiries as well as do periodic monitoring. And as most of you in the room and online will know, that CEDAW conducted an inquiry and issued recommendations on how abortion law in Northern Ireland could be decriminalised and how abortion could be made available in certain restricted circumstances. Those CEDAW recommendations were picked up on by an MP in Westminster and through a couple of amendments to Act of Parliament that were going through to try to get the executive re-established in Northern Ireland. She was able to secure the decriminalisation of abortion in Northern Ireland and the availability of abortion in cases of rape, incest, and fatal fetal abnormality. The legislation cites CEDAW in making those reforms, so you can draw a direct link there. But that's the only instance I find of direct impact of any of these bodies on changing policy and law. Turning then to the Council of Europe, I think its mechanisms are more effective, and that's partly because they are much better funded. I did some digging on this for the final chapter in this book and discovered that in the year 2022, the UN spent $8.7 million on the treaty body system. The Council of Europe spent $32.1 million on its monitoring systems. And that doesn't include the work done by Greta, the human trafficking body. The ILO, in its monitoring of the 8 human rights conventions, which have to do with employment rights, that are looked at by the committee of experts on the enforcement of the application of conventions and recommendations, no less than $25 million were spent just on that one UN monitoring system. That's more than 3 times as much as was spent on the treaty body monitoring system of the UN. So the UN system is partly inadequate because it's inadequately funded. But beyond that, the Council of Europe's system is better because, generally speaking, its review cycles are thematic. So when Greta or COMEX or even the European Committee on Social Rights looks at rights, it does them in groups and in accordance with certain themes. And that leads to a much more focused approach, not just by the state when reporting, but by the body itself when reporting back to the state. They often make visits to states rather than engaging in dialogue in Strasbourg. This dialogue there doesn't happen. The state doesn't send representatives to engage there. They wait for the visits to be made to the state by a small group of the committee members, not the whole group, of course. And some officials from the treaty body will come and will meet not just with state representatives, but with stakeholders of all kinds all around the place. And they will inspect on the ground what's happening. They'll go and talk to local ethnic minorities in certain places and hear from them what the situation is on human rights. Also, the Council of Europe bodies can fall back on the standard setting by the European Court, and they do that constantly, whereas the UN doesn't have that case law to fall back on. Yes, it has the case law emerging from the complaint handling system of the treaty bodies, but that's minuscule compared to the European Court's case law. The Council of Europe bodies are much more detailed in their assessments because of the word limit, there being no word limit, and because of their greater thematic approach. And if I was to hold up one body as being the best in Europe, indeed in the world, I think it's the European Committee of Social Rights. I spent a long time talking to Colm O'Cinada, who was vice president of the ECSR for a long while. And I'm pretty clear in my own mind, having looked at a lot of the reports, that it is by far the most effective of all these bodies. Apart from anything else, it asks for annual reports from each country on a set of rights, and it only takes about 18 months to issue its conclusions on those reports. And in its conclusions, it says the state has either is in conformity with the article of the social charter in question, or it's in conformity pending further information from the state, or it's not in conformity pending further information from the state, or fourthly, it's in non-conformity. There are 4 boxes which can be ticked in relation to each article of the European Social Charter, which the UK and every other country, depending on their selection, has decided to sign up to in the European Charter. So you get a much better feel for whether the state is complying. And if it's not complying, then the committee comes back in the next cycle and asks the state, why did you not do what we asked you to do last time round? So it's much more focused and symptomatic. And then last slide, please, Colin. I looked as well at the impact within the UK itself of these these bodies. I concluded that that we might think otherwise. A lot of the time, the UK actually does engage quite punctually and quite fully with its obligations, its reporting obligations. That's not to say it implements the recommendations all the time, but it does engage with the whole process. And that's partly pour encourager les autres. States, the big states in Europe want every state in Europe, the former Eastern Bloc countries, etc., to properly engage with these mechanisms as everyone else should be doing. As I said earlier, the devolved regions are getting a lot more attention by the treaty bodies and by the UK government itself, although, as I've noted in the article for the Northern Ireland Legal Quarterly, the fact that the Assembly and Executive here in Northern Ireland haven't sat for many years, since the Good Friday Agreement, there's been a lack of information sent from Belfast to London and from there to the treaty bodies in Europe. So they sometimes have gaps in their knowledge, which is filled sometimes by NGOs, but not always. I looked at how the national human rights institutions engage with the bodies. I'm glad to say the Northern Ireland Commission is the best of the three of them in that respect. Between the years 2000 and 2021, the Northern Ireland Commission submitted, let me just find this now. I think I've lost it here. I think it's over 60. There are 60 submissions on the NIHRC website relating to the treaty bodies, either at the UN level or the Council of Europe level. The Equality and Human Rights Commission, the GB human rights body, has a mixed record in this. It does have a human rights tracker system, which is very good, but it's only dealing with the UN treaty bodies, not the Council of Europe ones. It has a progress assessment tool whereby it puts into 5 different boxes the progress that the UK is making in relation to various rights, and that's all good and helpful. But the EHRC virtually ignores the European Social Charter. It ignores the International Labour Organisation's work, and the Scottish Human Rights Commission, I'm afraid, does the same. At the parliamentary level, the record was good up until about 2005. The Joint Committee on Human Rights within Parliament, the UK Parliament, did good work on UN treaty bodies. I would say it has dropped the ball since 2005. There have been lots of reports issued in Geneva and in Strasbourg from these bodies that the JCHR hasn't picked up on. In about 2006 or so, it issued recommendations on how the UK government could better engage with these bodies. It suggested, and I very much endorse this, that there should be a central or coordinating committee within government in London that is the go-to point for the treaty bodies and for NGOs wanting to interact with the treaty bodies, etc., so that the whole system works more efficiently across the board. Parliament itself pays little attention to any of these treaties. It did have a debate. There was a Westminster Hall debate on the UN Convention on the Rights of Persons with Disabilities just before it was ratified by the UK, but there's been very little else. And in the courts as well, I looked at how the courts have dealt with citations by lawyers of these treaty body recommendations. And as you can imagine, they're quite, well, to say that they're disparaging of them is over the top, but they're not prepared to give any authority to these treaty body recommendations whatsoever. And that was emphasised especially by Lord Reid in the SC case on the the 2-child limit for welfare benefits or tax credits just last year. So the courts don't pay them much attention, and Parliament doesn't pay them much attention, and the NHRIs could pay them more attention than they do. So I'm going to stop there, Colin. I'm happy to engage in a Q&A session. Thank you.
Thank you very much. Thank you very much, Brice, for a wonderful presentation. Much to think about there. Online audience would ask that if you have a question, put it in the chat box, and in-person audience to raise your hand. So, there's a question here.
Say that there are any positives to the UPR.
Okay, I'm not sure if the online people heard that, but the question was, are there any positives to the UPR? Yes, I mean, I'm in favor of the system because of its universality. Every state has to go through this system. And it's embarrassing for a lot of them. But it's also very easy for them to pull the wool over the eyes of the members of the Human Rights Council. And every state will have its friends on the HRC. And other states which want to make contributions to the UPR, because it's not just the 47 states that are members of the UPR that are engaged in this, it's any state that wants to be engaged. So it has a purpose in requiring every state to hold itself to account. But I'd be surprised if in any state one could draw a direct link between what the UPR concludes and a change of law or policy in that state.
Brice, thanks very much for this fascinating project. The methodology, the direct impact of evidence question, it sounds like a nightmare to try and draw it out, and I'm sure you had headaches with the beginning. I note your last point that it would be difficult for any state to draw a link between UPR and legislative change, but I wonder, do you think that the UK is perhaps I wouldn't say uniquely difficult, but particularly difficult whenever you begin to bring in constitutional identity issues around parliamentary sovereignty, dualism, this idea of constitutional rights being enough. Do you think that in the UK, the system is particularly reticent to recognise external drivers to domestic law changes?
I'm not sure I would, Conal. I mean, usually there are 1 or 2 recommendations after every UK UPR that there should be a written constitution for the UK. But it's quite easy for the UK to answer that kind of recommendation. It just sets out in its answer what the constitution of the UK is. Okay, it's not written in one document, but there is a constitution, and it's a flexible constitution in ways that others aren't. So I don't think that's been a particular problem. Of course, I have a huge problem in knowing whether the impact of these bodies on the UK is any worse or better than the impact on other countries. You'd need to do a comparative approach to that, and that would be a mammoth undertaking. There was a chap called Cromendijk in Europe who did look at the effect of the UN treaty bodies on Finland, the Netherlands, and New Zealand. I'm not quite sure why they chose those 3. But the book ends up not really comparing and contrasting as so much as telling you what happened in each jurisdiction, and you have to kind of draw your own conclusions as to whether it was better or worse in one jurisdiction. But there's a big grant available for somebody who wants to do a large comparative European piece of work, I would say.
Yes, thank you very much. So I'm reflecting on how a lot of your criticism of these bodies is founded on lack of funding combined with structural issues. But when you were talking about sort of weakness of the reasoning underpinning the recommendations or the evidence base underpinning the recommendations, and their skill, I suppose, at probing the credibility of NGO submissions, for instance, and that kind of thing. I find myself wondering, who is it that's doing this? What are their skills? What are their qualifications? Did you, as part of this, look into who's appointed to do this work and whether anything could be done to strengthen that aspect, I suppose, of their work?
I did ask questions around that. I mean, clearly a lot of the drafting, both at the UN and the Council of Europe level, is done by officials in the OHHCR in Geneva, or in the various offices in Strasbourg. But I'm told that the member of the committee who is a rapporteur for the particular country that's being examined will work very closely with the officials in drafting the concluding observations or the final report in the case of Council of Europe countries, and that it is the committee itself which signs off on the wording ultimately, and the changes are made at all stages. So it's not an entirely bureaucratic system at all, but obviously the officials are there to help ensure consistency, both time-wise and geographically wise, in the way these documents are worded. I would say that what rules the day is diplomacy. They're very conscious that there are only certain things you can say in a treaty body report. Maybe things even that there are things that judges can say, things that the Court of Human Rights can say, which a treaty body wouldn't say, because it would be politically unacceptable for that.
I say a bit more about that, Brice, actually. What do you mean by that? That's interesting.
Well, I mean, in a court case where the standards are, if they're not black and white, but there are certain precedents that one expects to be followed. If a country doesn't do that, then the court can spell that out. It can require compensation to be paid and other remedies to be given. These treaty bodies aren't in the mode of naming and shaming and punishing and imposing remedies. They are there to exhort, to persuade. And I mean, I think the people who sit on these committees are realists. They know that it's very difficult to eradicate racism, to eliminate poverty, all these huge issues. It's difficult for any country in any situation to do that. So that all adds to the need for these bodies to be a little bit more measured in their tone. And if they want states to fully cooperate with the system, they have to meet them, if not halfway, at least part of the way.
Okay. Anybody else in the room or online? Just in terms of just a quick comment. Quick, Tom.
You're looking for somebody else. You said you weren't looking at the investigations. I mean, my observation, without having done what you've done, is that it's the visits by the special rapporteurs to particular countries focusing on a particular issue that sometimes has a bit of impact. And these general reports are, as you say, not terribly helpful. One thing you didn't mention that I used to pick up at the UN was a worry about the burden being imposed on Fiji or Tumalali or Afghanistan that was completely incapable of doing this stuff was worrying.
You're right, Tom, that a visit and a report done by a special rapporteur can be very influential. And I've referred to one or two of those in the book. You'll remember the visit by the special rapporteur on adequate housing, where she was quite dismissive of the British system for protecting against homelessness and and other aspects of the housing law. That got quite a bit of coverage, but the government dismissed it out of hand. I think I cite somewhere where the government minister said this is just a lot of Marxist rubbish. You'll remember the working group on arbitrary detention that looked at the situation of Julian Assange when he was holed up in the Ecuador embassy. And they said that that was a breach of his right to liberty. And that was, I think actually the working group admitted later it was a bit of an own goal. It was legally very dodgy. It didn't go down well with the public in general, I think, in Britain. Not that I'm saying, Julian Assange should be extradited to America, but he chose to spend his time in the Ecuadorian embassy. And the thing about those special procedures are that they are very ad hoc. I mean, I'm sure if Fionnuala Ní Éileoin, who's a special rapporteur and a professor at the university here, if she was here, she'd be expressing her frustration at being able to do so little. I know she was in Guantanamo recently, which is great, but there are only so many state visits she can make every year. She can't be systematic. If any body can be systematic, it's these treaty bodies, and that's why I was focusing my attention on them. But I admit there are lots of other ways in which human rights can be improved, both by the UN bodies and other bodies, indeed.
Okay, well, I think perhaps the time to draw a line under the seminar this afternoon, to thank you all for attending both online and in person here today. And could we end by showing our appreciation to Professor Brice Dickson for a wonderful presentation?
Thank you.